This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. All right, so there's been a lot of talk about second impeachment, kind of like second breakfast. If you've been wanting Donald Trump to be impeached, well, you got something that we've never seen before. He was impeached a second time by the U.S. House of Representatives after the events of January 6th. And this is the first time that I think we've ever seen a president impeached twice. But now we have this new weird legal situation that doesn't have a whole lot of precedent. There is a second impeachment, but it was just before President Trump was set to leave office anyway on January 20th. So former President Trump has now left office, and the impeachment proceedings are now being sent to the Senate. I think they were sent on Monday or they're being sent on Monday. And I think there's supposed to be an impeachment hearing in the Senate starting on February 9th. I am not 100% clear on these dates, but that's what I think I've read recently. So what in the world would be the purpose of impeaching a president who has left office? What are the roles of impeachment with the House and the Senate? Well, the House is the body, the chamber of Congress that considers and passes the impeachment articles. And so this set of impeachment articles is based on the events of January 6th and whether or not Donald Trump, former president, had incited the events of January 6th. He had made many statements about election fraud, statements which were not founded in any evidence. That is not a conclusion of mine. I have basis for that in the fact that no evidence was presented in over 100 election lawsuits that were filed. And so there has been no evidence whatsoever presented in what I would consider to be over 100 investigations then, probably even more than the 100 lawsuits. There were cases like Frederick Eshelman, who hired True the Vote to investigate or donated to True the Vote to investigate, and they didn't find any evidence, and now he wants his money back. He donated millions of dollars, and now he's having a lawsuit with them, and he's filing temporary restraining order, trying to get them to put his money into escrow, or at least not spend any of the money so that he can get it back if he wins his lawsuit, because there was no evidence of any significant election fraud or voter fraud that would have overturned the results of the election. Now, this is a key distinction here that we really need to consider. There always is some small amount of voter fraud. There are people who try to vote twice, or try to vote on behalf of a dead person, or try to register to vote in a place where they don't live, or otherwise violate the voter registration rules. It does happen. I am, and many other people are not denying that these kinds of election fraud and voter fraud situations happen. The question is not whether it happens. The question is whether it happens enough to make a difference. If an election came down to one vote and there were 10 cases of voter fraud, that would be significant voter fraud, significant enough to overturn the election. So we would want to undo those votes, and we'd want to recount or retally the election results and see who wins without the voter fraud. But in the Georgia case, and in Pennsylvania and Arizona and all of the other elections, I think there was Minnesota or Wisconsin was another one that was challenged. There were thousands of votes difference, and there were not thousands of cases of voter fraud. So you wouldn't have a situation where the election outcome could change if any of the actual factual cases of voter fraud were undone, and they are undone. People do get caught, and the system is actually quite secure, as Brad Raffensperger had testified to, as William Barr had stated. There was no significant voter fraud. What the election lawsuits were all about seemed to be trying to undo the results of the election based on the procedures that were used, many times challenging mail-in voting rules that had been in place for years, if not, as short as maybe months, but challenging procedures for voting after the vote is not going to go well because of various legal doctrines. The philosophy, of course, is you don't change the procedures for voting after people have relied on it. The legal doctrine would kind of be like unjustified or justified reliance, a detrimental reliance. The applicable legal doctrine is actually called laches, which is kind of like a statute of limitations, but there is no actual statute saying 2 years or 3 years or 5 years. The doctrine of laches, when applied to election lawsuits, says that you don't change the outcome of an election after the election, or even slightly before the election. When voters are preparing to vote and they're in the middle of voting and the procedures have been in place for months to years, you don't change that at the last minute. If there's a challenge, bring the challenge much earlier and the court can actually make a decision, and that has happened in the past. When the challenge is brought early enough, then the courts do respond to those challenges. You also saw standing issues with the elections clause and electors clause election lawsuits. You don't have standing as a citizen to challenge somebody else's vote. You don't have standing as a state to challenge another state's votes. A citizen of Pennsylvania might have standing to challenge election laws in their county that apply to their own vote. That would be more realistic standing. But a citizen of Allegheny County, Pennsylvania, doesn't have standing to challenge the procedures used in Lehigh County, Pennsylvania, nor does Texas have the right to try and invalidate Pennsylvania's votes. Those are all standing issues. And then when those challenges are brought way too late, those are laches issues. So when I say there is no evidence of election fraud, all of that got to be adjudicated. All of those plaintiffs had the chance to present the evidence of needing a court remedy, and all of that evidence was not presented. There was no evidence of election fraud. So the president claiming that there was a massive amount of fraud, yet somehow nobody, not even very interested parties with no conflict of interest, they couldn't find it. So either we had the most well-hidden election fraud in the history of any U.S. election, or there actually wasn't any election fraud. There were claims that there were boxes of ballots that were being found. It turned out that those boxes were TV equipment from the TV station. There was a video of someone stuffing ballots into a ballot box. That was a video from a Russian election, not a video from a U.S. election. So the evidence was not only not there, but what was presented was fraudulent or made up evidence. And there really isn't any other conclusion I can come to than that there wasn't a stolen election. But yet the president maintained that and continued to ask people to come to D.C. and to fight for him and to go to the Capitol, etc. And so then let's do the evidentiary thing in the other direction. Is there evidence that Donald Trump incited imminent lawless action, as we saw in the Brandenburg line, the case of the First Amendment being limited by speech that incites imminent lawless action? Shouting fire in a crowded theater. Remember, I said that it had to have context. Certainly, the actors can shout fire in a crowded theater as part of the act, and that has to be taken in context too. If it is an actor who's trying to get the audience to believe that the actual theater is on fire and that they need to to panic and run to the exits and trample each other and cause death and dismay, that's imminent lawless action, and that would be inciting imminent lawless action. But if it is an actor shouting fire as part of the act, the set is a burning building, and part of the play is the burning building, then yeah, that's not inciting imminent lawless action. That is an act. So you can't just make these bright lines and say you can't shout fire in a crowded theater. Even that summary phrase has more behind it. And like that, though, there is more to the impeachment proceedings than the law. Impeachment proceedings are subject to the political question doctrine. The political question doctrine holds that a constitutional dispute that requires knowledge of non-legal character, or the use of techniques not suitable for a court, or expressly assigned by the Constitution to Congress or the President, lies within the political rather than the legal realm to solve, and judges customarily refuse to address such matter. The political question doctrine holds that some questions in their nature are fundamentally political and not legal, and if a question is fundamentally political, then the court will refuse to hear that case. It will claim that it doesn't have jurisdiction, and it will leave that question to some other aspect of the political process to settle out. So the impeachment in the House and conviction in the Senate impeachment process is not subject to judicial review. And we saw this in the first impeachment process. The first impeachment of Donald Trump involved, I think it was the Ukraine allegations, and many political commentators, constituents were upset that the Senate chose not to hold evidentiary hearings and instead just voted up-down on conviction without really much more than some of the senators speaking their minds. And so that's not really a court process. That's not fair in the legal sense of the word. But that's the political question doctrine. There aren't any courts that are going to rule, not even the U.S. Supreme Court is going to rule on whether the House can impeach and whether the Senate can convict. Instead, really the only time that the Supreme Court would get involved would probably be if a party had standing to present such a procedural violation to the court, such as whether or not Trump could be convicted after he's already left office voluntarily on January 20th. Maybe he can bring a case to the Supreme Court that says, you can't convict me of impeachment because I have already left. So impeachment involves the removal of the president from office, and according to some information I've seen, some other consequences that we're going to go over in a moment. So really, the only way I think that the Supreme Court would get to hear anything about impeachment would be if there had been a impeachment procedural violation brought either by a member of Congress or by former President Donald Trump himself. Now, on that note, there's a bunch of misinformation going around about the consequences of impeachment. So let's first take a look at this factcheck.org article here. It says a viral tweet that migrated to Facebook distorts the facts and consequences of a potential second impeachment. Impeachment alone would not strip Trump of his pension or bar him from pursuing office in the future. The House is pursuing a potential second impeachment of Trump. They impeached him again on January 13th or 14th or 15th or something around that time. But a viral message says, for those wondering if it's worth impeaching him, it means he loses a $200,000 pension, $200,000. It means he loses a $200K pension. He loses his $1 million a year travel allowance and security allowance. He loses his Secret Service detail, and he loses his ability to run in 2024. Apparently, none of those are true, at least not like that. The prospect of Trump losing his ability to run in 2024 is not automatic as a result of impeachment or conviction. If the Senate did convict, they can hold a separate vote to also disqualify him from holding future office. There is some debate over whether the Constitution's language about such disqualifications would apply to the presidency. Professor Brian Colt says that he believes it does. Another professor, Peter Smith, specializes in constitutional law, said that the argument that the presidency wouldn't qualify for disqualification is generally considered an outlier view, one that is based on a very close parsing of constitutional text that would lead to some very surprising results. As to stripping Trump of benefits, such as his pension, staff, and annual security and travel allowance, the act says those benefits would not apply to a president whose service is terminated by removal, pursuant to Section 4, Article 2 of the Constitution, which addresses impeachment and removal. It appears unlikely that a potential Senate trial, and therefore any possible conviction, would take place before Trump leaves. It obviously didn't. And Professor Blackman argues that in his reading, the exclusion of benefits would not apply to a president who is convicted after he has already left office. If he is impeached before January 20th, yes, but a former president cannot be removed from a position that he no longer holds. Smith said it was reasonable to read the law's text that way, but in theory, there could be judges who would find that Congress meant to disqualify presidents who are convicted in an impeachment trial, that it hadn't considered presidents convicted after leaving office. The viral tweet also says that President Trump loses lifetime full Secret Service detail, but that's also not true. Trump would still be eligible for the Secret Service protection even if the president was removed from office. He would almost certainly not automatically lose his Secret Service protection, which he would otherwise expect to receive after January 20th. The power of the Secret Service to protect former presidents is authorized by a separate statute, 18 U.S.C. 3056. There's no reason to think the definition of a former president used in the Former Presidents Act would apply to the Secret Service protections provided to former presidents under the law. Finally, the Former Presidents Act authorizes $1 million per fiscal year for security and travel-related expenses for former presidents, provided the former president was not receiving protection for a lifetime provided by the Secret Service. So in other words, the law does not provide both lifetime Secret Service protection and $1 million in travel and security allowance, as the Post suggests. So the loss of those benefits is probably not a reason to impeach. The reasons to impeach would be more philosophical, would be the justice of the impeachment, the meaning of holding the president accountable for what he is accused of doing. And whether or not he actually did the things that he's accused of doing really isn't going to be decided by the Senate. A conviction in the Senate is not the same thing as a conviction in a court. Conviction in the Senate means they're answering a political question, not adjudicating a legal dispute according to the rule of law. There will be no evidentiary rules that really need to be applied. The Senate can choose how they want to proceed, and you saw last year that they chose to proceed without presenting any evidence, without allowing parties who wanted to present evidence. They could do that again. They could just hold an up-down vote on whether they agree with the impeachment proceedings or not, and convict or acquit. It's sort of a misnomer to be using the same terms in the same way as we do in the criminal law, because there is no beyond a reasonable doubt standard for the acquittal or conviction in the impeachment process. And there is no further review by the Supreme Court to make sure that some evidentiary process or due process or evidentiary standard was used during the adjudication. So this is very much a political question, and it will be decided by politicians according to rules set by themselves. So maybe we need to back off from some of the rhetoric, maybe we need to back off from some of the misinformation, and probably just see what happens, as there will be few consequences to convicting or acquitting the former president in this second impeachment trial. You don't necessarily have to like or dislike this. We are all entitled to our opinion about this one because this is what it's left to, is the political process. So whereas I normally disagree with things that have no evidentiary basis or violate due process or violate other legal or philosophical principles, this one is more of a debate, and then politicians get to decide whose side they're on. And then there's the question as to whether the former president can even be tried in the Senate because he's already left office. Well, let me tell you quickly the story of William W. Belknap. He was a lawyer, a soldier in the Union Army, a government administrator in Iowa, the Secretary of War serving under President Grant, and he was impeached on March 2nd, 1876. For his role in the Trader Post scandal. Apparently, he received kickback payments derived from a tradership contract between Caleb Marsh and John Evans. Skipping that story, if we go to his Senate trial and acquittal, he was tried in the Senate on April 5th, 1876. The senators argued over whether the Senate had jurisdiction to put him on trial since he had already resigned office in March. Defense managers argued that the Senate had no jurisdiction. The Senate ruled by a vote of 37 to 29 that it did. Belknap was charged with 5 articles of impeachment, and the Senate listened to over 40 witnesses. With 40 votes needed for conviction, the Senate voted 35 to 25 to convict Belknap, with 1 senator not voting, thus acquitting him of all charges by failing to reach the required 2/3 majority. All senators agreed that he took the money from Marsh, but 23 who voted for acquittal believed that the Senate did not have jurisdiction. Grant's speedy acceptance of Belknap's resignation undoubtedly saved him from conviction. And that's something that might happen here. Donald Trump already left office. The senators who vote to acquit might simply say, he's already left office, it's not a big deal, what's the point? Whereas if he was still in office and still provoking further January 6th style events, maybe that would make it an easier decision. But again, this is not an evidentiary due process adjudication. This is a political question. So let me know what you think in the comments below. Again, keep it civil. I will heavily moderate inflammatory comments, but I'm not going to be holding people to an evidentiary standard when we are discussing a political question. Thank you for watching. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program, here on YouTube, also on Floatplane, and on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern. Our channel is community supported by your monthly financial contributions on patreon.com/ljfrench, sponsors.com/law, through YouTube membership, and through Floatplane subscriptions. Thank you to the following $50 plus supporters in the month of January: Joe Tyson, Mitchell Rowton, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Andy, Benjamin Hitov, Goliath Cleric, Ugly Grill, Shielo T, Rudolph Bescherer Jr., Oscar the Phrophet, HotGrillsInYourArea, Torpedan, Brandyn Abel, Cassandra Curran, Sovereign Tittizen, ShadowTycho, RDHDragon, Earthbound Star, Nathan McCarty, and Awful Asses with Lemon Fresh. And thank you as well to the $5 plus supporters who are scrolling on your screen. I hope everyone has a great week. I will see you in the videos that drop. I love you all. Bye.